Hello, and today we're going to be having a look at the criminal offence of rape, which is covered under Section 1 of the Sexual Offences Act 2003. Before we begin, I want to make a quick announcement that I realise I refer to these whiteboard flowchart type diagrams in the background, and you might not be able to see what is written, so I will have JPEG pictures of the whiteboard attached on my website underneath the video, so you'll be able to have a closer look at them, and they might help you. So let's begin with rape. Now, rape, there are three parts to the actus reus. The first two are fairly self-explanatory. The first is there must be penile penetration. What is the significance of this? Well, the significance of this, it means that rape can only ever be committed by a man. It cannot be committed by a woman. If a woman forces a man to have sex with her, that will come under a different type of sexual offence under the Act, probably creating another person to engage in a sexual activity or sexual assault, something along those lines. And the second part to the actus reus, so far I'm just following those two, I'm not sure you can see, is that the penile penetration must be of the vagina, anus, or mouth. Now, what is the significance of this? It means that even though rape can only be committed by a man, the victim can be both a man and a woman. And it shows also that times have changed, because historically rape was only understood to be involving vaginal penetration, but now this has changed to include the anus and the mouth. Okay, so moving on. Now, the last part of the actus reus, which is the really key bit, is that there must be no consent. So, how can we show that at this act, during this act, there was no consent? Well, there's three ways of going about it. The first one is the prosecution can establish a conclusive presumption exists. Basically, what happens is if you meet certain requirements that this presumption requires, then the courts will deem there to be no consent, and the defendant cannot use the defense in the mens rea saying, oh, but I was led to reasonably believe that there was consent, as it will be deemed without any defense, whatever the defendant said makes no difference, that there was no consent. It's conclusive. Now, this presumption can be found in section 76(2) of the Sexual Offences Act, and there's two types, A and B. So what are they? Well, the first one involves deception as to the nature or the purpose of the relevant act. So the classic cases involve flattery, 1877, where the defendant forces the victim to have sex with him on the grounds that it's a medical treatment. And the second one is Williams, 1923, where the defendant forces the victim to have sex with him on the grounds that it will improve your singing. So obviously these are examples of rape because the person did not want to sleep with him, but obviously they ended up doing so because there was a deception as to the nature and purpose of the act. However, this is not as wide as one may think at first appearance, because if you look at, for example, the case of Lineker, 1995, the man didn't pay the prostitute after sleeping with her. They said that this wasn't to do with the nature, there was no deception as to the nature of the act, so this presumption could not exist. There is some query, though, that the whole purpose of the act was for the prostitute to make money, so surely she was deceived into that. Nevertheless, that's what the ruling tells us. And similarly, in the case of B, 2006, the presumption wasn't successfully used, where the man failed to make sure the woman he was sleeping with had consented to sleeping with him with knowledge that he had HIV. The court said that something like HIV, it's not rape, because obviously she is consenting to the sexual activity. What she's not consenting to is the infecting of disease, and that comes under great grievous bodily harm, so do not bring it under rape, basically is what they were telling the prosecution. And a final case example is Devenol, 2006. It was actually not to do with rape, it was to do with the offence of causing another to perform a sexual activity. Nevertheless, they couldn't use consent because the court said the victim had been deceived as to the purpose of the act, because they thought the purpose was to give pleasure when actually was to create embarrassing material of the victim. So that's the first type of conclusive presumption. The second type in section 76 2b is where the defendant intentionally induces the complainant to consent to the relevant act by impersonating a person known personally to the complainant. Now, this is fairly straightforward, but the key point to know here is it cannot be some celebrity or some far-fetched fantasy. It has to be someone they knew personally, for example, the victim's boyfriend or husband, something along those lines. Now, the second type is evidential presumptions, and these are found under Section 75 of the Act. Now, this differs from conclusive presumption in the sense that if the defendant shows evidence that he had reasonable grounds to believe that the victim did consent, then these presumptions can be rebutted. Now, there's 6 types. They go from A to F. I'm going to quickly just go over them. There's not really much cases to say because they're fairly self-explanatory. So the first one, A, is any person was at the time of the relevant act or immediately before using violence against the victim. So the key point there is, was there violence against the victim? Then obviously there's no consent. The second one is same violence, but the violence is used against another person who's not the victim. C is where the victim was detained at the time, but the defendant was not detained at the time, so kidnapping cases. E is where the defendant had a physical disability, which meant that they weren't able to communicate their consent, therefore it counts as no consent. This isn't the same for people with mental disabilities, but it is for physical disabilities. And that was E, and I forgot to say D was if the defendant is asleep or unconscious. Obviously, how can they consent unless you find evidence saying that, oh, me and the woman, we had this thing going on where she liked to be asleep and I would come in and jump on her, or I don't know, that's the example the textbook gives. And F, finally, which is drug rape cases. Obviously, if you give someone a drug rape, then it's not a consensual sexual activity. So the last one is where the victim did not consent, but under the general meaning of the word, and obviously this can be rebutted. Now, this is to be found in section 74 of the Act, where it says a person consented if he agrees by choice and has the freedom and capacity to make that choice. And there's several issues here we need to look at, because the key words being agrees, choice, freedom, capacity. These are the 4 main words. So the first thing to talk about is this idea of agreement versus submission. The courts have realized that there's a difference, and in Robinson 2011, they made it clear that the law requires a positive agreement, not just like a person being terrified, as was the victim in Jita, and going along with the sexual activity. The second thing is capacity. What are we talking about here? We're talking about 3 things. We're talking about children, and we're talking about children, people with mental disabilities, and people who are intoxicated. So what do we mean by this? So Gillick and West Norfolk and Wisbech Area Health Authority, 1986, this case made it clear that where a child who is a child, which is somebody under 16, has sufficient competence to understand what is proposed, then he or she can consent to medical treatment. They can consent to sexual activity if they show sufficient competence. And the courts will probably, there's not much to go by, adopt a similar test when they're looking at people in relation to the Mental Capacity Act 2005. Now, the problem with this idea of drunk cases is that if you look at the case of Bree 2007, they said you can confirm even if you're drunk. So we're talking about a case where people are not that drunk. But obviously, it's also pretty clear that if you are really drunk, you have no recollection of what happened in R and H, then you may also lack the capacity to consent. So the problem is for people who are fairly drunk, and it's usually to do with the facts of the case and the scenario of whether you had the capacity to make a choice. So that's not something I can give you a black and white rule on, but it is left to the juries, and it will depend on every situation. Then we need to look at this idea of freedom. What do we mean that you need to have the freedom to make the choice? Well, in Jita, the defendants had sent the victim messages purporting to come from the police and insisting that she have sex with the defendant or face a fine. It was held that this was no consent because she didn't have the freedom. She was terrified by these threats. A classic example being somebody's got a gun to your forehead. And the last issue we need to look at is this idea of conditional consent. So in Assange and Swedish Judicial Authority 2011, the issue arose whether Assange could be convicted of rape because the woman agreed to have sex, but she didn't agree. She agreed to have sex with a condom, and he didn't use a condom. And basically, the court held that this would be an offence in England because she didn't have the potential to make that choice, and it was a case of conditional consent. This can be sort of shown in comparison to RF v DPP 2013. Basically, the complainant agreed to have sex on a basis that the defendant would not ejaculate, but he did. So she complained to the police, and the CPS said this is not rape, especially after Assange was decided. They said, no, this is not it. But they sent lawyers anyway to have a look at the decision again, and the question they were thinking about is whether the complainant had the freedom to make consent. So it will depend on every situation, but it's this idea of somebody being able to make a choice freely, and obviously in the light of something like using a condom where you're looking at sexually transmitted diseases, this is really important. If you, however, look at a condition like I will only engage in this activity if you buy me flowers or something, obviously the courts are not going to take that seriously. So that's the actus reus done. Now we're going to move on to the mens rea, which is over there. This can be finished quite shortly because it's quite a long video, I realise. Well, the first thing is you need to have the intention, aim or purpose to penetrate the vagina, anus or mouth. This is pretty clear because, as the textbook says, you don't just accidentally penetrate the vagina, anus or mouth. So that's fairly obvious. Then the second thing is that you will be found to have met all the requirements of rape unless you can show that you reasonably believe that there was consent. This, however, doesn't apply if the conclusive presumptions are utilised. And if the evidential presumptions are utilised, then you have to have evidence relating directly to that evidential presumption that's used. So if it says under D, for example, that the victim was asleep or unconscious at the time, you need to bring evidence that no, they were in their full senses, and yes, they said that they were happy to engage in this activity. However, most rape cases look at the idea of consent in the general meaning of the word. So there you're having a look at, well, did the defendant believe that there was consent? And what is the evidence showing that they believed that there was consent? And if so, was this belief a reasonable one? And the key case here we're going to look at is DPP and Morgan, 1976. This is where they use the defense of honest yet unreasonable belief, because basically the man invited 3 people to sleep with his wife, and he told them that, she might complain, she might do this, X, Y, Z, but she's just going along with it. And so basically the 5-panel judge in the House of Lords said that when the defendant had genuinely believed, then there was no grounds to charge him under. This was understood as a rapist charter, and I don't think that would likely to apply today, and I think the reasonable belief is more of an objective test today, and then we use a more common sense approach with the juries then, as we saw in DPP and Morgan. I'm really in a rush to finish this video, sorry it's a bit long. Thank you for watching.